The legal framework of drink driving in the UK. The legal landscape governing drink driving in the United Kingdom is multifaceted and stringent, primarily governed by the Road Traffic Act 1988, RTA 1988. A thorough understanding of the specific offences, the prescribed alcohol limits, and the critical legal distinctions is the foundational first step in navigating any allegation. An arrest for drink driving does not automatically lead to a conviction. The prosecution must prove its case beyond a reasonable doubt, and the law provides specific avenues for challenge and defence. This section deconstructs the legal architecture of drink driving offences in the UK. The core offences under the Road Traffic Act 1988, RTA 1988. The RTA 1988 establishes several distinct but related criminal offences concerning the consumption of alcohol and the use of motor vehicles. While often colloquially grouped under the single term, drink driving, the specific charge brought against an individual has profound implications for the evidence required by the prosecution and the potential defences available to the accused. The principal offences are driving or attempting to drive with excess alcohol. This offence, under Section 5 of the RTA 1988, is the most common charge. It pertains to an individual driving or attempting to drive a motor vehicle on a road or other public place when the proportion of alcohol in their breath, blood, or urine exceeds the legally prescribed limit. Being in charge of a vehicle with excess alcohol, also under Section 5 of the RTA 1988, this offence applies to individuals who are not necessarily driving but are deemed to be in charge of a vehicle while over the limit. This is a crucial distinction with different penalties and defences. Driving or attempting to drive while unfit through drink or drugs. This offence, under Section 4 of the RTA 1988, does not rely on a specific alcohol measurement. Instead, it requires the prosecution to prove that a person's ability to drive properly was impaired due to the consumption of alcohol or drugs. Being in charge of a vehicle while unfit through drink or drugs. Similar to the above, this Section 4 offence applies to a person in charge of a vehicle whose ability to drive is impaired, without the need for the prosecution to prove they were actually driving. Failing to provide a specimen for analysis. Under Section 7 of the RTA 1988, it is a serious offence to fail, without a reasonable excuse, to provide a required evidential specimen of breath, blood, or urine at a police station. Refusing to cooperate is not a way to avoid a charge. It constitutes a separate offence with severe penalties. Defining the prescribed limit, breath, blood, and urine levels. The cornerstone of the most frequent drink driving charge is the prescribed limit. It is essential to recognize that these are fixed legal thresholds, and it is impossible to state with certainty how many alcoholic drinks will place an individual over these limits. Factors such as weight, age, sex, metabolism, food intake, and stress levels all affect alcohol absorption and processing rates. In England, Wales, and Northern Ireland, the legal limits are among the highest in Europe and are as follows. Breath, 35 micrograms, μg, of alcohol per 100 milliliters, ml, of breath. Blood, 80 milligrams, mg, of alcohol per 100 milliliters, ml, of blood. Urine, 107 milligrams, mg, of alcohol per 100 milliliters, ml, of urine. It is a critical point of awareness for any driver that the limits in Scotland are significantly lower, having been reduced in December 2014. This creates a situation where a driver could be legally compliant in England but break the law by crossing the border into Scotland. The prescribed alcohol limits in the UK are as follows. England, Wales and Northern Ireland. Breath limit, 35 micrograms, 100 milliliters. Blood limit, 80 milligrams, 100 milliliters. Urine limit, 107 milligrams, 100 milliliters. Scotland. Breath limit, 22 micrograms, 100 milliliters. Blood limit, 50 milligrams, 100 milliliters. Urine limit, 67 milligrams, 100 milliliters. Sources. Furthermore, much stricter, near-zero tolerance limits apply to professionals in safety-critical roles, such as pilots, train drivers, and commercial vehicle operators, reflecting a legislative approach that grades the acceptable level of risk. The international context is also stark. Many European nations operate with a 50 milligrams, 100 milliliters blood alcohol limit, the same as Scotland, while several Eastern European countries enforce a zero-tolerance policy. Distinguishing key offences: excess alcohol, unfit to drive, and failing to provide. The choice of charge laid by the Crown Prosecution Service, CPS, is a strategic one that dictates the entire nature of the case. Understanding the elements the prosecution must prove for each is fundamental to identifying a potential defense. Excess alcohol, S.5 RTA 1988. This is what is known as a strict liability offense. The prosecution's task is relatively straightforward. They must prove beyond a reasonable doubt that the defendant was driving or in charge of a vehicle on a public road and that their alcohol level, as measured by a reliable, approved evidential device, was over the prescribed numerical limit. The quality of the person's driving is legally irrelevant to this charge. A person could be driving perfectly but still be guilty if their reading is over the limit. The key evidence is almost always the printout from the evidential breath testing instrument, EBT, or a laboratory certificate for a blood or urine sample. Unfit to drive, S.4 RTA 1988. This charge is fundamentally different. Here, the prosecution must prove that the defendant's ability to drive was impaired as a direct result of consuming drink or drugs. This is not about a number but about a state of being. The prosecution will rely on evidence such as police officer testimony about erratic driving, e.g., weaving across the road, the defendant's physical appearance, slurred speech, glazed eyes, admissions made at the scene, or performance in a field impairment test. A conviction for being unfit is possible even if a subsequent test shows the driver was technically under the prescribed limit, provided the evidence of impairment is sufficiently strong. Failing to provide a specimen, S.7 RTA 1988. This is a standalone offense. It is committed when a person, without a reasonable excuse, fails to provide or refuses to provide an evidential specimen of breath, blood, or urine when lawfully required to do so by a police officer. The penalties are deliberately severe and are often benchmarked against a high-reading drink driving offense to ensure that refusing the test is not seen as an easy way out. The prosecution must prove that a lawful and procedurally correct requirement was made, and that the defendant's failure to comply was not justified by a valid reasonable excuse. The existence of these distinct but overlapping offenses provides the CPS with significant strategic flexibility. This creates a challenging, multi-front legal battleground for any defendant. The prosecution will almost always prefer to proceed with the excess alcohol charge under Section 5, as it relies on objective, scientific evidence from the EBT machine, which is generally easier to prove than the subjective impairment required for a Section 4, unfit, charge. However, this reliance on technology is also its greatest vulnerability. If the defense can successfully challenge the validity of the EBT result, for instance, by demonstrating a critical procedural error was made during the test or that the machine was faulty, the Section 5 charge may fail. In such a scenario, the CPS is not necessarily defeated. They can still pursue a conviction under the alternative Section 4, unfit to drive, charge, falling back on the police officer's observational evidence of the defendant's driving standard and physical state. This means that a defense strategy focused solely on a technical challenge to the breathalyzer is incomplete and high risk. A robust defense must be prepared to fight on two fronts. First, by forensically examining the technical evidence for the Section 5 charge, and second, by being ready to challenge and undermine the subjective, observational evidence for the alternative Section 4 charge. This dual requirement fundamentally shapes the complexity, scope, and potential cost of mounting a successful legal defense. Here is a summary of the key drink driving offenses and the elements the prosecution must prove. Driving with excess alcohol, S.5, 1, RTA 1988. What the prosecution must prove: the defendant was driving or attempting to drive on a road or other public place, and their alcohol level in breath, blood, or urine was over the prescribed limit. Primary evidence: evidential breath test, EBT, printout or laboratory analysis of blood, urine. Driving while unfit through drink, S.4, 1, RTA 1988. What the prosecution must prove: the defendant was driving or attempting to drive on a road or other public place, their ability to drive properly was impaired, and the impairment was due to drink. Primary evidence: police officer testimony, driving standard, physical state, witness statements, field impairment test results. Failing to provide a specimen, S.7, 6, RTA 1988. What the prosecution must prove: a lawful and correctly conducted requirement for a specimen was made, the defendant failed or refused to provide it, and they had no reasonable excuse for the failure. Primary evidence: officer testimony, MGDD procedural forms, custody suite CCTV. Sources: the critical distinction, driving versus in charge, and its legal implications. Within the offences under Section 4 and Section 5, the law makes a further crucial distinction between the act of driving and the state of being in charge of a vehicle. This distinction is one of the most significant in drink driving law because it directly impacts the penalty, particularly the imposition of a driving disqualification. Defining driving, the term driving is generally interpreted by the courts to require that the vehicle is in motion, even if only for a very short distance. It implies active control over the vehicle's movement. Defining in charge, this is a much broader and more fact-specific legal concept. It is not necessary for the vehicle to be moving or for the engine to be running. A person can be deemed in charge in a variety of circumstances, such as being asleep in the driver's seat, sitting in a parked car with the keys in the ignition, or even being outside the vehicle but in close proximity with the keys and the ability to exert control over it. The court will consider all the circumstances, including the person's location within or near the car, the location of the keys, whether the engine was running, and any evidence of their intention to drive. The legal significance of this distinction is profound. A conviction for driving or attempting to drive with excess alcohol carries a mandatory minimum 12-month driving disqualification. The court has no discretion to avoid imposing a ban. In contrast, a conviction for being in charge with excess alcohol does not carry a mandatory ban. The court has the discretion to either impose a driving ban or, alternatively, to endorse the driver's license with 10 penalty points. This makes the driving versus in charge argument a vital strategic battleground. Where the prosecution's evidence of the defendant actually driving is weak or non-existent, e.g., they were found in a stationary vehicle by police, a defense solicitor will vigorously argue that the case is, at most, one of being in charge. Successfully persuading the prosecution to accept a plea to the lesser in charge offense, or convincing a court of this at trial, can be the difference between a defendant keeping their license, albeit with 10 points, and receiving a lengthy disqualification. The police investigation, from roadside stop to police station. The entire drink driving prosecution process is built upon a sequence of procedural steps, each providing the legal justification for the one that follows. This procedural chain, from the initial decision to stop a vehicle to the final evidential test at the police station, is governed by strict legal rules. A failure by the police to adhere to these rules at any stage can create a loophole or a point of legal challenge that may undermine the entire prosecution case. Understanding this chronological process is therefore essential to identifying potential procedural defenses. The legal grounds for a police stop and request for a breath test. While police officers have a general power under Section 163 of the RTA 1988 to stop any vehicle at any time, their power to require a breath test is not unlimited. The concept of a truly random breath test is a misconception in UK law. An officer must have a specific legal basis for requiring a driver to cooperate with a preliminary breath test, PBT. Under Section 6 of the RTA 1988, a police officer in uniform may require a PBT from a person if one of the following three conditions is met. Reasonable suspicion of alcohol. The officer reasonably suspects that the person is driving, attempting to drive, or is in charge of a vehicle and has alcohol in their body. This suspicion can be formed from various observations, such as the smell of intoxicants on the driver's breath, slurred speech, unsteady movements, or the driver admitting to having consumed alcohol. It is important to note the suspicion is merely of having any alcohol in the body, not necessarily of being over the limit. Moving traffic offense. The officer reasonably suspects that the person has committed a traffic offense while the vehicle was in motion. This is a very broad power and can be triggered by any number of infractions, from serious offenses like running a red light or speeding, to more minor issues like briefly crossing the center line of the road. The officer does not need to prove the offense was actually committed, only that they had a reasonable suspicion that it was. Involvement in an accident. An accident has occurred owing to the presence of a motor vehicle on a road or other public place, and the officer reasonably believes that the person was driving, attempting to drive, or in charge of the vehicle at the time of the accident. This applies to all drivers involved, regardless of who was at fault. The lawfulness of the entire case rests upon the legality of this initial interaction. If an officer cannot justify the requirement for a PBT under one of these three grounds, any subsequent evidence, including the results of the evidential test at the station, could be rendered inadmissible in court. The legal grounds for a roadside breath test are suspicion of alcohol. This is based on an officer reasonably suspecting the driver has alcohol in their body. Examples include the smell of alcohol, slurred speech, glazed eyes, an admission of drinking, or erratic driving. Moving traffic offense. This is based on an officer reasonably suspecting the driver has committed a traffic offense while the vehicle was in motion. Examples include speeding, using a mobile phone, running a red light, careless driving, or having defective lights. Involvement in an accident. This applies when an accident has occurred and the officer reasonably believes the person was driving or in charge of the vehicle. This covers any road traffic collision, regardless of who was at fault. Sources: the roadside procedure, preliminary breath tests, PBT, and field impairment tests. Once a lawful requirement has been made, the roadside procedure commences. The preliminary breath test, PBT. This is conducted using a small, handheld screening device. It is crucial to understand that this test is not evidential. Its purpose is solely to give the officer an indication of the presence of alcohol and to provide the legal grounds for an arrest if it is positive. The PBT result itself cannot be used in court to prove that a driver was over the limit. Refusing to cooperate with a lawfully required PBT without reasonable excuse is a separate offense under Section 6(6) of the RTA 1988. The field impairment test, FIT, if an officer suspects impairment by drugs, or if a PBT is not available or appropriate, they may require the driver to undertake a field impairment test. This is a series of standardized physical coordination tasks, such as walking in a straight line, turning, standing on one leg, or touching one's nose with a finger. The procedure for conducting and assessing this test is detailed in the official police form MGDD-F. Failure of this test can also provide grounds for arrest. The arrest, the caution and your immediate rights. If a driver fails the PBT or FIT, or refuses to cooperate with the test, they will be arrested on suspicion of a drink or drug driving offense. At the point of arrest, the officer is legally required to do two things. State the fact that the person is under arrest. State the ground for the arrest, e.g., I am arresting you on suspicion of driving with excess alcohol. The officer will then administer the police caution. You do not have to say anything. But it may harm your defense if you do not mention when questioned something which you later rely on in court. Anything you do say may be given in evidence. Following the arrest, the individual will be transported to a designated police station for the purpose of obtaining an evidential specimen. It is imperative to cooperate and not to physically resist the arrest, as this could lead to additional charges such as resisting an officer in the execution of their duty. Procedure at the police station. The evidential breath test, EBT. The police station is where the most critical phase of the evidence-gathering process occurs. Upon arrival, the arrested person will be booked into custody by a custody sergeant. This involves taking personal details, explaining their rights, including the right to legal advice, and conducting a search, during which items like shoes may be temporarily removed for safety reasons. The central procedure is the evidential breath test, EBT. This is not the same as the roadside PBT. The EBT is conducted on a large, highly sophisticated, and Home Office-approved stationary machine, such as an Intoximeter EC, IR, a CAMIC Datamaster, or a Lion Intoxilyzer 600 UK. The result from this machine is the primary evidence the prosecution will rely on in court. The procedure is highly formalized. The law requires the person to provide two separate specimens of breath into the machine. The police will use the lower of the two readings as the definitive evidential value. If a person provides a reading over the legal limit, they will be formally charged with the offense. The MGDD forms a deep dive into the procedural paperwork, MGDD-A, MGDD-B. The entire station procedure is not left to the officer's memory or discretion. It is meticulously scripted by a series of documents known as the Manual of Guidance Drink and Drug Driving, MGDD, forms. These forms are the prosecution's own record of the procedure they followed. For the defense, they are the single most important source of evidence for identifying procedural errors. Form MGDD-A, Evidential Breath Procedure. This is the key document in the vast majority of drink driving cases. It is a multi-page booklet that contains the precise, verbatim questions, requirements, and statutory warnings that the officer must read to the suspect. Any deviation from this script can form the basis of a legal challenge. Key steps prescribed by Form MGDD include asking about consumption in the last 20 minutes to rule out mouth alcohol contamination from a recent drink, food, or mouthwash. Reading the formal requirement for 2 specimens of breath and the statutory warning that failure to provide is an offence punishable by imprisonment, a fine, and disqualification. Recording the exact results from the EBT machine's printout and providing a copy to the suspect. Form MGDD-B, Evidential Blood, Urine Procedure. This form is used when a breath sample is not taken, for example, due to a medical condition or a faulty EBT machine. It scripts the procedure for requiring a blood or urine sample, including obtaining consent and involving a healthcare professional. Other forms. The MGDD series also includes forms for specific situations, such as Form MGDD-C, Hospital Procedures, Form MGDD-D, Post-Driving Consumption and Back Calculation Defenses, Form MGDD-E, Laboratory Submissions for Blood, Urine, and Form MGDD-F, Roadside Impairment Testing. When blood or urine samples are required, the legal basis and procedure. While breath is the default method for evidential testing, there are specific circumstances where the police must instead require a sample of blood or urine. These are not arbitrary choices and are legally defined. A requirement for blood or urine can be made if the evidential breath testing machine is unavailable, has malfunctioned, or has produced a result that is deemed unreliable, e.g., it detected an interfering substance. The suspect has a genuine medical reason, supported by evidence or accepted by the officer, for being physically unable to provide a breath sample, e.g., severe asthma or a serious chest condition. The suspect has been taken to hospital following an accident. The choice between blood and urine is at the discretion of the police officer, though blood is generally preferred for its accuracy. A urine sample requires the suspect to provide 2 samples within 1 hour, with the first being discarded and the second used for analysis. If a blood or urine sample is taken, the suspect is typically released on police bail without charge, pending the results of the laboratory analysis. This process can take several weeks. A critical right for the suspect in this scenario is that the sample must be divided into 2 portions. One portion is sent to the forensic laboratory for the police, and the other must be offered to the suspect for their own independent analysis. Accepting this sample and having it analyzed by an accredited laboratory is a crucial step in any potential defense, as it can be used to verify or challenge the prosecution's findings. The police are required to provide the suspect with a leaflet explaining how to store and handle their portion of the sample to maintain its integrity. The entire police procedure can be viewed as a chain of evidence. Each step must be legally justified by the one that preceded it. A flaw in an early link can have a domino effect, poisoning the entire chain and rendering all subsequent evidence inadmissible. For example, if the initial stop was unlawful because the officer had no reasonable suspicion under any of the 3 legal grounds, then the requirement for a PBT was also unlawful. If the PBT was unlawful, then the arrest based on its result was unlawful. And if the arrest was unlawful, then the requirement to provide an evidential specimen at the station was also unlawful, meaning the court may exclude the EBT result from evidence. This is why a defense solicitor's first action is not to look at the final breath reading, but to work backwards, meticulously scrutinizing the legality and procedural correctness of every single step. Was the initial stop justified? Was the officer in uniform when they requested the PBT? Was the arrest caution given correctly? Was the MGDD, a procedure, followed to the letter? The police's own paperwork, particularly the MGDD forms, becomes the most critical piece of evidence for the defense. An error, an omission, or an inconsistency recorded in these documents can provide the grounds needed to argue that the prosecution's case is fatally flawed and should be dismissed. This transforms the procedural forms from mere administrative documents into the central battleground of the case. Your legal rights, navigating the process. When subjected to a drink driving investigation, an individual is not without rights. The Police and Criminal Evidence Act 1984, PACE, provides fundamental protections to all persons detained at a police station. However, the unique, time-sensitive nature of drink driving evidence creates a crucial tension with some of these rights, particularly the right to legal advice. Understanding the scope and limitations of these rights is essential for navigating the process correctly and preserving potential grounds for a legal challenge. The right to legal advice under PACE 1984. Upon being arrested and detained at a police station, an individual has an absolute and non-negotiable right to consult with a solicitor, free of charge. This is enshrined in Section 58 of PACE 1984. When a detainee requests legal advice, the police are under a positive obligation to facilitate that consultation, as soon as is practicable. This right is fundamental to ensuring fairness in the criminal justice process. The critical limitation: why legal advice cannot unduly delay the evidential test. Herein lies the most critical and often misunderstood aspect of a drink driving arrest. The body naturally metabolizes and eliminates alcohol over time. To obtain an accurate evidential sample that reflects the level of alcohol at the time of driving, the RTA 1988 requires the police to conduct the test in a timely manner. This creates a direct conflict between the need for a prompt sample and the right to wait for a solicitor. The courts have resolved this tension decisively. Case law, most notably the High Court judgment in Kennedy v. CPS*, has established that the public interest in obtaining a reliable breath specimen for the investigation of a serious offense takes precedence over a suspect's right to delay the procedure to wait for a solicitor to physically attend the police station. Therefore, a detainee cannot refuse to provide a sample on the grounds that they are waiting for their solicitor to arrive. An insistence on doing so will be treated by the police and the courts as a refusal, leading to a charge of failing to provide a specimen under Section 7 of the RTA 1988. However, this does not extinguish the right to legal advice entirely. The judgment in Kennedy also clarified that the police must still make reasonable efforts to facilitate advice if it can be obtained without causing a significant delay. If a solicitor is immediately available, for example, if they are already present in the custody suite for another client, or if they can be reached by telephone for a brief 2-minute consultation, then the police should permit this to happen before the procedure continues. The key is that the delay must be minimal. A wait of many minutes would be considered impracticable, and the police would be within their rights to press on with the evidential test. Consequences of denying access to legal counsel: challenging evidence. If the police make no reasonable attempt to facilitate a requested consultation with a solicitor, or if they improperly deny access when a solicitor is readily available by phone, this can constitute a significant breach of the suspect's rights under PACE Section 58. This breach can form the basis of a powerful legal argument at trial. A defense solicitor can apply to the court to have the evidence obtained after the breach, namely the result of the breath, blood, or urine test, excluded from the trial. This application is made under Section 78 of PACE, which gives the court the discretion to refuse to allow evidence on which the prosecution relies if it appears that, having regard to all the circumstances, including how the evidence was obtained, its admission would have such an adverse effect on the fairness of the proceedings that it ought not to be admitted. If the court agrees that the breach of the right to legal advice was substantial and unfair, it can exclude the test result. Without this core piece of evidence, a charge of driving with excess alcohol cannot succeed, and the prosecution's case will collapse. This provides a vital remedy for a defendant whose fundamental rights have been violated. The practical value of requesting legal advice in this context is therefore not necessarily to be told whether or not to provide the sample. Any competent solicitor, when contacted, will almost invariably advise their client to provide the required specimen, as refusing to do so constitutes a separate and equally serious offense. The true strategic value lies elsewhere. The very act of requesting a solicitor immediately changes the dynamic of the situation. It puts the police officers on notice that their actions and adherence to procedure will be subject to professional legal scrutiny. It transforms what might be treated as a routine administrative task into a formal legal procedure conducted under observation. This heightened scrutiny often ensures that officers are more meticulous in following the complex, scripted MGDD, a procedure to the letter. Furthermore, it creates a contemporaneous record of the detainee actively asserting their legal rights. Should the police then make a procedural error or improperly deny a brief telephone consultation, the defense is in a much stronger position to argue at trial that the subsequent evidence was unfairly obtained. Therefore, requesting a solicitor, even if the full consultation does not happen until after the test is completed, is a critically important strategic step for any person detained on suspicion of drink driving. Your rights regarding specimen samples. In addition to the right to legal advice, a suspect has specific rights pertaining to the samples they provide. Breath samples. As established, the law requires 2 separate evidential breath specimens. The suspect has the right for the lower of these 2 readings to be the one relied upon by the prosecution as evidence. This provides a small but important safeguard against machine fluctuations. Blood and urine samples. If a blood or urine sample is taken, the suspect has an absolute statutory right to be offered their own portion of that sample for independent analysis. The police must divide the sample, typically giving one vial to the suspect and retaining the other. It is of paramount importance to Accept this offer, the suspect's sample can then be sent to an independent, accredited forensic laboratory. The results of this independent analysis can be used to corroborate the prosecution's findings, challenge the prosecution's findings if there is a significant discrepancy, identify potential issues with the police laboratory's analysis or handling procedures. The police are obliged to provide a leaflet explaining the correct procedures for storing and handling the sample to maintain its evidential integrity. Failing to accept the offered sample effectively means forfeiting the best opportunity to mount a technical challenge to the prosecution's scientific evidence. Challenging the allegation, potential defenses and loopholes. A charge of drink driving is not unassailable. The law provides for a number of specific defenses and allows for challenges to be made against the evidence presented by the prosecution. The term loophole is often used, but in a legal context, it refers to a failure by the prosecution to prove its case beyond a reasonable doubt, often due to a procedural flaw, an unreliable piece of evidence, or the successful assertion of a recognized legal defense. These challenges focus on the integrity of the legal and scientific process that leads to a charge. Procedural errors, the foundation of many successful defenses. The most common and often most effective way to defend a drink driving allegation is to identify a significant procedural error made by the police during the investigation. The process is complex and highly regulated, creating numerous opportunities for mistakes. This type of defense does not argue that the defendant was not over the limit, but rather that the evidence of them being over the limit was obtained unlawfully and is therefore inadmissible. The foundation of this defense is a meticulous, forensic audit of the police's own paperwork and evidence, primarily the MGDD forms and custody suite CCTV footage. Examples of procedural flaws that can be fatal to a prosecution case include incorrect statutory warning. The police officer must read the formal requirement and warning from the MGDD, a form verbatim. Any significant deviation, omission, or error in delivering this warning can invalidate the requirement, meaning a subsequent failure to provide a sample may not be unlawful. Errors in MGDD form completion. The MGDD forms are the prosecution's own record of the procedure. An incorrectly completed form, contradictory entries, or missing information can be used to cast doubt on whether the procedure was followed correctly. Failure to observe pre-test conditions. The MGDD, a procedure requires the officer to ask about consumption of food, drink, or medication in the 20 minutes prior to the test to avoid mouth alcohol contamination. A failure to ask this question or to wait the required period if the answer is yes, is a significant procedural breach. Improper blood, urine procedure. The procedure for taking non-breath samples is also strictly regulated. For example, consent for a blood sample must be obtained in the presence of the healthcare professional who will take it. If an officer obtains consent before the nurse or doctor arrives, the consent may be invalid, and the sample inadmissible. Technical defenses, challenging the reliability of breathalyzers and samples. This line of defense focuses on the scientific integrity of the evidence itself. While modern evidential breathalyzers are highly reliable, they are not infallible. Breathalyzer reliability. A direct challenge to the general reliability of Home Office-approved devices is almost impossible in a magistrate's court. However, it is possible to challenge the reliability of the specific device on the specific occasion of the test. This requires evidence of a malfunction, which could include printout anomalies. The EBT machine produces a detailed printout. Error messages, e.g., ambient fail, interfering substance detected, or a significant, unexplained variance between the two breath readings beyond the accepted tolerance can indicate a fault. Misinterpreted errors. An officer might mistake a machine error message for a failure to provide by the suspect. An expert analysis of the machine's operational log or printout might reveal that the fault lay with the device or the operator, not the suspect. Calibration. While all devices are periodically calibrated, obtaining and successfully challenging these records is difficult. The prosecution is not typically required to disclose service records unless the defense can provide a proper evidential basis to show they are relevant. Physiological factors and mouth alcohol. Certain medical conditions or substances can contaminate a breath sample, leading to an artificially inflated reading that does not accurately reflect the alcohol level in the deep lung air. This is often referred to as the mouth alcohol defense. Potential causes include gastroesophageal reflux disease, GERD, or recent vomiting. These conditions can cause alcohol from the stomach to regurgitate into the esophagus and mouth, leading to a high reading on a breath test that is not representative of the blood alcohol level. Dental issues, poorly fitting dentures or dental work can trap alcohol in the mouth. Diabetes. In rare cases, particularly with older or poorly calibrated machines, the ketones produced by a person with diabetes, especially during a state of ketoacidosis, can be misidentified as ethyl alcohol. Medications and mouthwash. Some products contain alcohol and, if used very recently before a test, could contaminate a sample. The 20-minute observation period is designed to prevent this, but a failure to follow that procedure could make this defense viable. Continuity of evidence, chain of custody. For blood and urine samples, the prosecution must be able to prove an unbroken chain of custody from the moment the sample was taken from the suspect to the moment it was analyzed at the laboratory. Any gap or inconsistency in this chain, for example, mislabeled vials, improper storage, or a flawed paper trail, can be used to argue that the court cannot be sure the sample analyzed was the correct, uncontaminated sample from the defendant. The hip flask defense. Post-driving consumption explained. This is a specific, statutory defense, often called the hip flask defense, where the defendant admits to being over the limit at the time of the police test, but argues that this was due to alcohol consumed after they had finished driving but before they were tested. A classic scenario is a driver who is involved in an accident, gets home, and consumes alcohol to calm their nerves before the police arrive. Under Section 15(2) of the Road Traffic Offenders Act 1988, the law presumes that the alcohol level in the specimen is not less than it was at the time of driving. The hip flask defense seeks to rebut this presumption. The burden of proof shifts. Unlike most criminal matters where the burden is on the prosecution, in this defense, the burden of proof shifts to the defendant. The defendant must prove, on the balance of probabilities, a lower standard than, beyond a reasonable doubt, that their alcohol level would have been below the prescribed limit at the time they were driving. Evidence required. This defense is highly technical and virtually impossible to succeed with unless supported by expert evidence. The defense must instruct a forensic toxicologist to produce a back calculation report. The expert will consider the defendant's height, weight, gender, the precise amount and type of alcohol consumed post-driving, the timings of the last drink and the police test, and the evidential reading obtained. They will then provide a scientific opinion on what the defendant's reading would have been at the time of the alleged driving. The credibility of the defendant's account is also paramount. The court must believe their explanation for why they drank after driving. The drunk in charge defense, proving no likelihood of driving. As established, being in charge of a vehicle with excess alcohol is a distinct offense. While the prosecution must prove the in charge element, the RTA 1988 provides a specific statutory defense. The burden of proof shifts. The defendant must prove, on the balance of probabilities, that at the time they were alleged to be in charge, there was no likelihood of them driving the vehicle whilst they remained over the prescribed alcohol limit. Evidence required. This defense is entirely dependent on the specific facts of the case. The defendant must build a credible narrative to convince the court they had abandoned any intention of driving until they were sober. Evidence could include proof of a call to a taxi firm or a friend, family member to arrange a lift. Witness testimony from the person who was coming to collect them. Evidence of being asleep in the vehicle, particularly in the passenger or rear seats, with the clear intention of sleeping it off. A toxicologist's report calculating the time at which the defendant's alcohol level would have naturally fallen below the legal limit, combined with evidence that they did not intend to drive before that time. Reasonable excuse for failing to provide a specimen, medical and other grounds. This is the only statutory defense to a charge of failing to provide a specimen under Section 7 of the RTA 1988. The defendant must show they had a reasonable excuse for their failure to provide the required sample. Medical excuses. This is the most common and most successful form of this defense. It requires a genuine physical or mental condition that directly prevented the provision of the specific sample requested. There must be a clear causal link. It is not enough to simply have a medical condition. That condition must have been the reason for the failure. Examples include breath sample, severe asthma, chronic obstructive pulmonary disease, COPD, or another respiratory condition that physically prevents the person from providing a long, steady flow of breath into the machine. A sudden anxiety or panic attack at the station could also qualify. Blood sample, a genuine, medically diagnosed and documented phobia of needles, trypanophobia. A mere dislike of needles is insufficient. Urine sample, a urinary tract infection, UTI, prostate problems, or another medical condition that makes urination on demand impossible. Non-medical excuses. These are almost never accepted by the courts. Established case law has confirmed that the following do not constitute a reasonable excuse: being too drunk to understand the requirement, feeling stressed by the situation, refusing to provide a sample until a solicitor is physically present, or holding religious beliefs that forbid the procedure. Evidence required. To succeed with a reasonable excuse defense, it is essential to have corroborating expert medical evidence from a doctor or specialist who can provide a report and potentially testify in court, confirming the medical condition and explaining how it caused the failure to provide the sample. It is also vital that the defendant raised the medical issue with the police at the time of the procedure. Other potential defenses: duress, automatism, and private land. These defenses are rarer and apply in more unusual circumstances. Duress of circumstances. This defense argues that the defendant was compelled to commit the offense of drink driving by an immediate threat of death or serious harm from an external source. The classic example is fleeing a violent attacker. The legal bar is extremely high. The threat must be imminent, the defendant must have reasonably believed it, and the act of driving must have been a reasonable and proportionate response with no safe alternative. Automatism, a very rare defense where the defendant argues they were not acting voluntarily and were not in conscious control of their actions. This might apply in the case of a person with diabetes who suffers a sudden hypoglycemic episode, a hypo, causing them to drive in an automatic, unconscious state. This requires strong expert medical evidence. Driving on private land. The drink driving offences specified in the RTA 1988 can only be committed on a road or other public place. A public place is one to which the public, or a section of the public, has access. If it can be proven that the driving occurred exclusively on land that is genuinely private, with no public access, e.g., a farmer's field, a private driveway with a closed gate, this is a complete defense to the charge. The landscape of potential defenses reveals that the most effective challenges are often not based on dramatic courtroom revelations but on the forensic auditing of routine police work. The value of a specialist solicitor frequently lies in their meticulous, systematic scrutiny of the prosecution's own evidence, the MGDD forms, the EBT printouts, the custody CCTV footage. They are searching for the small but critical inconsistency, the missed procedural step, or the incorrectly ticked box. This reframes the idea of a loophole, away from a secret legal trick and towards a failure by the state to meet the high procedural and evidential standards that are required by law to secure a criminal conviction. Special reasons. Mitigation to avoid mandatory disqualification. In the rigid landscape of drink driving law, where a conviction for driving over the limit results in a mandatory minimum 12-month disqualification, the legal doctrine of special reasons provides a narrow but critical exception. It is not a defense. A finding of special reasons means the defendant is still found guilty of the offense and will receive a criminal record. However, it gives the court the discretion to step away from the mandatory penalty and impose a lesser sentence, most significantly, by not imposing a driving ban or imposing a shorter ban. This doctrine acts as a judicial safety valve, allowing courts to avoid outcomes that might be considered manifestly unjust in highly exceptional circumstances. However, its very existence and the extremely high threshold for success reinforce the otherwise strict and unforgiving nature of the offense. It is the exception that proves the rule of the law's general intolerance for excuses. Defining special reasons, the four key criteria. For an argument to qualify as a special reason, it must satisfy four strict criteria established by case law. The reason must be a mitigating or extenuating circumstance, not amount to a legal defense in itself, be directly connected to the commission of the offense, be something that the court should properly take into consideration when imposing punishment. The most critical element is that the reason must be connected to the offense, not the offender. This means that personal hardship, such as the fact that losing a license will cause the defendant to lose their job or create difficulties for their family, cannot amount to a special reason. Common arguments: spiked drinks, shortness of distance, and emergencies. While any set of facts could potentially give rise to a special reasons argument, the courts have typically considered three main categories. Spiked or laced drinks. This is where a defendant argues that they unknowingly consumed alcohol because their drink was spiked. To succeed, the defendant must convince the court, on the balance of probabilities, of two things. First, that they genuinely did not know and could not reasonably have been expected to know that their drink contained the extra alcohol, and second, that without the additional, surreptitiously administered alcohol, their reading would have been below the legal limit. This is an exceptionally difficult argument to win, as courts are often skeptical and require credible, corroborative evidence beyond the defendant's own word. Shortness of distance driven. This argument is made when the distance driven was so minimal that it can be said there was no real danger to other road users or pedestrians. Examples might include moving a car a few feet in a private car park to allow another vehicle to pass. The court will closely scrutinize the circumstances. Why was it necessary to drive at all? Was there an intention to drive further? What was the nature of the location? If the driving, however short, occurred on a public road with other traffic present, the argument is far less likely to succeed. Driving in a genuine emergency. This applies where the defendant drove in response to a sudden and unforeseen emergency. The classic example is a life-threatening medical situation, such as a person suffering a heart attack or going into labor, where calling an ambulance was not a reasonably viable alternative. The court will conduct a rigorous examination of the facts. Was the emergency genuine and as serious as claimed? Was driving the only option? Why could the emergency services not have been used? How far was driven? The high burden of proof for special reasons arguments. In all special reasons hearings, the burden of proof rests on the defendant. They must establish the factual basis of their claim on the balance of probabilities. Given the serious public policy implications of not disqualifying a drink driver, courts approach these arguments with a high degree of skepticism. Success is rare and almost always requires compelling and, where possible, independent corroborative evidence. This might include witness testimony, e.g., from the person who spiked the drink or the person suffering the medical emergency, medical records, or expert reports. A persuasive and well-prepared legal argument that systematically addresses why no other reasonable course of action was available is essential. Sentencing and consequences, the court process and beyond. A conviction for a drink driving offense carries consequences that extend far beyond the courtroom. The penalties are severe, and the process is designed to be a strong deterrent. The final outcome is determined by a combination of the specific offense, the level of alcohol recorded, the defendant's plea, and a range of aggravating and mitigating factors. The impact of a conviction can be life-altering, affecting employment, insurance, international travel, and personal finances for many years. The court process. Pleading guilty versus not guilty. Following a charge, the defendant will be bailed or summoned to appear at a magistrate's court for a first hearing. At this hearing, they will be required to enter a plea. This decision is strategically critical and has immediate consequences. Pleading guilty. If the defendant pleads guilty, the case proceeds directly to conviction and sentencing, usually at the same hearing. The most immediate consequence is that the driving disqualification takes effect instantly. The defendant will be banned from driving from the moment the sentence is passed and will not be permitted to drive home from the court. Pleading guilty at the earliest opportunity entitles the defendant to a reduction in the punitive part of the sentence, the fine, community order, or prison term. This reduction can be up to 1/3, but, crucially, it does not apply to the length of the driving disqualification. Pleading not guilty. If the defendant pleads not guilty, the court will set a date for a trial, which may be several weeks or even months later. A significant consequence of this plea is that the defendant is legally permitted to continue driving until the conclusion of the trial. This provides time to prepare a defense and to get one's affairs in order in anticipation of a potential ban. However, if found guilty at trial, the defendant loses the credit for an early guilty plea, meaning the punitive part of the sentence will be higher. There is also the risk of incurring greater legal costs. This framework creates a powerful but often misunderstood strategic dilemma. A defendant facing a mandatory ban, even with a weak defense, has a rational incentive to plead not guilty if the primary goal is to maximize their time on the road. By doing so, they trade a potentially higher fine for several more months of being able to drive legally. The length of the disqualification, if they are ultimately convicted, will be the same regardless of when the plea was entered. This highlights that the best legal strategy is not always clear-cut and depends heavily on the defendant's personal, professional, and financial priorities. Sentencing guidelines explained how penalties are calculated. Sentences for drink driving are not arbitrary. Magistrates are required to follow comprehensive sentencing guidelines issued by the Sentencing Council to ensure consistency. The single most important factor determining the severity of the sentence is the evidential alcohol reading. The guidelines are structured in brackets, with higher readings leading to significantly harsher penalties. The sentencing guidelines for excess alcohol, attempt to drive, in England and Wales are as follows. For a breath reading of 36 to $59 μg 100 milliliters, or 81 to 137 milligrams, 100 milliliters blood, 108 to 183 milligrams, 100 milliliters urine. The starting point is a Band C fine, 150% of relevant weekly income, with a disqualification range of 12 to 16 months. For a breath reading of $60 to $89 μg 100 milliliters, or 138 to 206 milligrams, 100 milliliters blood, 184 to 274 milligrams, 100 milliliters urine. The starting point is a low-level community order with a disqualification range of 17 to 22 months. For a breath reading of $90 to $119 μg 100 milliliters, or 207 to 275 milligrams, 100 milliliters blood, 275 to 366 milligrams, 100 milliliters urine. The starting point is a medium-level community order with a disqualification range of 23 to 28 months. For a breath reading of $120 plus μg 100 milliliters, or 276 plus mg, 100 milliliters blood, 367 plus mg, 100 milliliters urine. The starting point is 12 weeks custody with a disqualification range of 29 to 36 months. Note, a minimum 36-month disqualification applies for a second offense within 10 years. Sources. As the guidelines show, there are significant cliff edges. A reading of $89 μg in breath places a defendant in the community order bracket, while a reading of $90 μg moves them into a higher level community order. A reading of $120 μg or more places the defendant at risk of an immediate custodial sentence, even for a first offense. The offense of failing to provide a specimen is also punished severely, with the sentence depending on the court's assessment of the reason for the failure. The guidelines are honestly held but unreasonable excuse for refusal. The starting point is a low-level community order with a disqualification range of 12 to 16 months. Deliberate refusal or failure. The starting point is a medium-level community order with a disqualification range of 17 to 28 months. Deliberate refusal or failure, with evidence of serious impairment. The starting point is 12 weeks custody with a disqualification range of 29 to 36 months. Note, a minimum 36-month disqualification applies for a second offense within 10 years. Source. Aggravating and mitigating factors in sentencing. Once the starting point is determined by the alcohol reading, the court will adjust the sentence up or down based on aggravating and mitigating factors. Aggravating factors make the offense more serious and will lead to a harsher penalty. They include previous convictions for similar offenses, carrying passengers, especially children, evidence of an unacceptable standard of driving, being involved in an accident, or committing the offense in an area with a high level of traffic or pedestrians. Mitigating factors may persuade the court to impose a more lenient sentence. They include having no previous convictions, a timely guilty plea, evidence of genuine remorse, being of good character, the driving being over a very short distance, or the offense arising from a genuine emergency that did not meet the high bar for a special reason. The Drink Drive Rehabilitation Scheme, DDRS, for any disqualification of 12 months or more, the court has the discretion to offer the defendant the opportunity to attend a Drink Drive Rehabilitation Scheme, DDRS, course. This is a voluntary course for which the defendant must pay. Upon successful completion of the course by a specified date, the total length of the driving disqualification will be reduced by up to 25%. The High Risk Offender Scheme. The law identifies certain individuals as high-risk offenders. This category includes anyone convicted with an alcohol reading of more than 2.5 times the legal limit, e.g., above $87.05 μg in breath, 200 milligrams in blood, or 267.5 milligrams in urine. Anyone convicted of 2 drink driving offenses within a 10-year period. Anyone convicted of failing to provide a specimen for analysis. For these offenders, the driving license is not automatically returned at the end of their disqualification period. They must apply for their license to be reinstated and, as part of that process, undergo and pass a medical examination with a DVLA-appointed doctor to prove that they are medically fit to drive and do not have a continuing problem with alcohol misuse. The wider consequences: insurance, employment, and international travel. The formal court-imposed sentence is only the beginning of the consequences. A drink driving conviction has a long and damaging legacy. Criminal record. A conviction for drink driving results in a criminal record. The endorsement remains on a driving license for 11 years from the date of conviction. Car insurance. Insurance costs will increase significantly upon the return of a license. Convicted drink drivers are considered high risk, and many mainstream insurers will refuse to provide cover, forcing the driver to seek expensive specialist insurance. Employment. The conviction can lead to immediate job loss, particularly if driving is a requirement of the role. Future employment prospects can also be damaged, as employers can see the conviction on a license check. International travel. A criminal conviction for drink driving can create significant difficulties for travel to certain countries, most notably the USA and Canada, which have very strict admissibility rules. This can impact holidays, study, and work opportunities abroad. Conclusion. The law surrounding drink driving in the UK is deliberately complex and severe, reflecting a strong public policy to deter and punish such behaviour. However, the severity of the consequences is matched by a high procedural and evidential burden on the prosecution. An allegation of drink driving is not an open and shut case, and a conviction is not a foregone conclusion. This analysis has demonstrated that the legal framework is built upon a series of distinct offences, each with specific elements that must be proven beyond a reasonable doubt. The police investigation itself is a chain of evidence, a highly regulated and scripted process where each step must be conducted lawfully to justify the next. A failure at any point in this chain, from an unlawful stop to a flawed breath test procedure, can be sufficient to cause the collapse of the entire prosecution case. The concept of loopholes is, in reality, an examination of these procedural requirements and the legal rights afforded to an individual. The right to legal advice, though limited by the practical need for a timely sample, remains a cornerstone of fairness. The various statutory and common law defenses, from challenging the reliability of scientific evidence to arguing no likelihood of driving or reasonable excuse, provide legitimate avenues to contest a charge. Even after a conviction, the narrow doctrine of special reasons offers a final opportunity to mitigate the mandatory penalty in truly exceptional circumstances. Ultimately, the sentencing framework is rigid and the long-term consequences of a conviction are profound, affecting every aspect of a person's life from their finances to their freedom of movement. Navigating this high-stakes legal environment requires more than a superficial understanding of the law. It demands a meticulous, forensic approach to the evidence and a deep knowledge of procedure, case law, and legal strategy. Given the complexity of the issues and the severity of the potential outcome, the single most important step for any individual facing a drink driving allegation is to seek specialist legal advice from a qualified solicitor at the earliest possible opportunity.